today we don't want to talk about too much theoretical legal topics, but rather about what you should learn if you study law, what we think it's basic to learn if you don't just want to be someone who is applying the law, but to understand the law and apply the law in a ethic way. So we have now again Michael and me here. So Michael, what is your opinion? What someone should learn in law?
Yeah. Today we have no coffee. That's the problem. Unfortunately.
Coffee, yeah?
No, it's okay. It's without coffee. Yeah, later. That's true. No, because I talked a lot of times with my good friend Stefan about the subject, what law students should learn. Yeah, it's a good friend. So
A lot of times.
a lot of, 2 times. So twice.
Exactly today.
Yeah, today. But nevertheless, no, just kidding. The problem is, I remember when I studied abroad, there was mostly the question whether something is good law or bad law. And I think that, especially in law German study, you don't learn to decide on your own whether something is good law or bad law. The problem is that in the German law system, it is more or less that you have to solve cases in your law study, because you have a very technical approach of the law. It has some advantages. The advantage is that it is more foreseeable than in other law systems, I think, because it's a highly technical subject. But on the other hand, the fundamental question whether a solution of a case is good law or not, that's not to the law student. They don't learn to think about it. And I think we should find ways to integrate it more in our teaching. How do you do it in your teaching, Stefan?
Well, I take care, as you know, Michael, I am not teaching law students, but students from economic science and people who do evening courses also sometimes. And so normally my colleagues would think, they should know the basics of the structures and so, but I think more important than knowing about details of the paragraphs, of the articles in the civil code, they should know about the philosophical background and the constitutional background, and teaching about constitutional background, which is ruling everything in the law. Also the civil law, of course, is on the same hand philosophical background, because the constitutional aspects of the fundamental rights are, of course, having the roots in the philosophy. So I think it's very important that more important than knowing about when some article has to be applied in a very specific way. They should understand, but more important is to know about this background. And so I try to integrate maybe also topics which are philosophical, and maybe even me in my study as a law student, my professors did not maybe integrate it. I integrated. How do you do it?
I think that the most important point is that you must try to explain it to ordinary people. I have the idea that law must be understandable for everybody, at least the basics. It's not that every case can be decided by anybody, so that's not the problem. The problem is that it must be possible for a lawyer to explain the fundamental points of a case to others. So, and I think especially when you teach no law students, you can tell them how the law is working, how are the principles applying in practice, because this leads to a situation where people really believe in law, even when they don't understand the concrete case decision by a court. But when the law seems for people to be something like a hidden science where only specialists can talk about and it has nothing to do with their life, then I think it has a problem with acceptance in society. And so I try to discuss it from this way. Last time I heard a very good lecture by a colleague. He taught about civil law, 1 hour. And it was for business students. And he started with a regulation, with a rule, after 45 minutes. What I want to say is he didn't mention any rule for 45 minutes, just explaining the interests important in the case, just explaining what is the economic background, why should there be a solution, how can it look such a solution. So that was really impressive. It was one of the best lawyers I've ever heard teaching law, and that must be our idea, that there are principles and of course there are also rules in the end, but nevertheless, first of all, you have to understand the principles, and this is possible by everybody, whether he's lawyer or is law student or not a law student or not a lawyer.
Maybe I can transfer it to something, some experience I have in Indonesia. Sometimes I was mentioning this in presentations in Indonesia. When I'm in Indonesia, then after my lecture, often there are students asking me, Prof, what should Indonesia do to regulate certain things we regulate in the EU? And then should we just maybe transfer this, because you have a very good rule here, and should we just transfer it? And that is what Indonesia sometimes do or did, transferring certain rules which coming from international situation, from other regulations in other countries, and transferring it to Indonesia. And then we wonder why the enforcement of that rule is very heavy in Indonesia. So I always used to answer, and this is really highly connected with what you mentioned, I always answer, it is not enough to know a rule, to see a rule and to say, wow, this rule is dealing with a certain problem. You must know about the background or the surrounding of the application and integration of a rule into a certain legal system. And the legal system is never separated from the culture and from the history. So if you just transfer rules without taking into account this background, social background, economical background, historical background, then it would fail. And this is what young students, especially in Indonesia, should learn before they come into the practice, before they go to the ministries, to understand that law is based in culture. Good law is grown in a culture. The civil code in Germany is not only from 1900. It is based in the Roman law. It is based in certain German peculiarities. It is the consequence and the product of a long research on German law and European law traditions. Yeah, and this is what students must learn. This connection between culture and law.
And they must learn also that in the end, at least in civil law, the rules are the balance of interest. Every rule is a decision how you want to solve a case and how do you want to balance interests. And those interests are changing during times. It's not that they are the same interest 100 years ago, as you already said, with the German civil code from 1900. So the first question is always, where are the interests and how are these interests balanced by law? And then you can come to own decisions. And they can be different, but nevertheless, you go to it from the rules. And that's true. And that's not what you are learning, because they are not learning so much, because now you have so many rules, a system full of rules, and so it's difficult for students to learn a lot of them. But in the end, when they are a judge, and you have been a judge, Stefan, at the end you are sitting there and you have to balance interests. Whatever you do. There are rules, they can help you, but nevertheless, you have to come to a decision. Every case is different. For sure, most of the cases are different from others. So in the end, it is a fundamental question. What do you think? What do you believe? What is the position of the interest in a specific case?
This is very true. And I used to tell my students here and in Indonesia, if we are if we are radical, we could maybe bring a lecture down to maybe 4 to 5 basic principles they should understand. I always used to tell them, when you are 10 years later or 15 years later, what will you remember? You will not remember in which paragraph is written something. You will not remember about the scheme, maybe the test we learned here, but what you maybe remember, what is the principle of bona fides? Yeah, what is the principle? What you say is so important. Interest equilibration, a rule for ruling interests which are colliding. Yeah, it's conflict solutions. This is or trust. What does trust mean in the society, and then how the trust should be regulated and handled in the law. Law is not what many people think, something above the people or a separate system beside the society. Law is an instrument which is integrated and should be integrated into society.
Thank you, Stefan. See you again.
Again, a pleasure. We come back.
Next lecture will come soon.
And the next time with coffee again. So we call it today without coffee in Corona.
Bye.
Bye-bye.